Welcome, everyone. This is an amazing opportunity because for the first time in Ibis Prep history, we have 2 weeks of general review for the MBE. In the past, we used to start after January, and then we were like, ooh, we're rushing it. So we started in the middle of December. And then this administration, I put my foot down and said, you know what? We're going to move the Ibis Prep Christmas party to the first weekend of December. And then that Monday, I'm hitting the ground running. No time off, we're getting to work. And just so you all know, a little testament to my business and what we've got going on, we just signed a major contract to do securities tutoring for a major broker dealer. So Series 7, Series 66, and SIE, and 63 and 65. And the main instructor for Ibis Prep securities tutoring has two thumbs, and it's this guy right here. So as soon as this bar prep ends for me, I'm going off to teach people about the securities exams, and the show continues. So just take things in stride. This is what you're doing right now, but as soon as you pass this test, get your license, you're going to start working as an attorney, you're going to get on big assignments, and the ship sails forward. There's this former student of mine. His name is Michael Levy, and he is the son of a trust and estates attorney in my BNI. BNI is called Business Networking International. It's a business networking group where you meet with a bunch of other business owners and you give your commercials and then you refer each other business. And that's how I met Jeff, the father, who's a very successful, prominent attorney in Miami. He actually went to elementary school with my mother. That's how deep these roots are in Miami. And his son needed to pass the bar exam, came to my class, my very first ever Florida bar prep class when I started this, and he crushed it. And no doubt, never heard from him again until about a month ago. He comes to my BNI meeting as a visitor. Now he's a member. And I gave my presentation on my business. Oh, Ibis Prep, we're the best business to ever live, whatever. And he gets up in front of the class and says, I would not be an attorney if it wasn't for him. This is the guy who changed my life. And I'm like, yeah, say it louder. And then after the meeting, I was like, go and say, what's up, bro? How long time do we see? How you doing, man? What's up? And he's like, man, the number one thing is not just because he worked with one of my instructors, Letty. He's like, and he came to my class. He's like, it's not just the information you taught us. It was that belief in self, that not only was I going to pass this test, I was going to crush this test. Like, yeah, okay, other people are going to, oh no, I might pass, I might fail, but not us, not my students, not the people in my world. We are going to go so far past the finish line that we're going to look back and be like, wow, there's people who didn't even make it to the finish line. What are they doing back there? That's the attitude. So he said when he finished that test, there was no doubt in his mind that he passed the test. Now he comes to my BNI meetings. He stands up every week and gives a commercial about trusts. No, sorry, about what do they do? Title, real estate law, right? Real estate title, big money stuff, right? I have ADD. I don't even pay attention to other people's commercials, but that's what he's talking about. Title, real estate, big money stuff. He's the man, right? He's the man. And he passed his test working with me, and he embodied the belief in self. And I still think that resonates with him today. And he's about to take over the world. If you need a good title and estate attorney, Michael Levy, that's my guy. He's a former Ibis Prep student, and now he's a big boss attorney. And he's the youngest person in my chapter, but he has probably one of the most coveted positions, the real estate attorney. So just know there's major opportunities out there for you, but it's things you got to take in stride. We have to pass this test first, and then the opportunities will be abundant after that. So today we started class by doing what I call the pinwheel of life, right? The pinwheel of life is this wheel that I've spun around. I asked every single student in the class a question, except for those who opted out, and they were able to provide the answer. Like, here's an example. I could say contracts, and I could say, what's the difference between the UCC and the common law when it comes to contract formation and contracts execution? And the answer would be the UCC for formation is the battle of the forms provision, which means an additional term, so long as it's not material, will be included in the contract unless the offeror explicitly rejects within a reasonable time, such as 10 days. Now, under the common law, we need the mirror image test, which means that the offer and the acceptance must match exactly. So remember, common law, formation, mirror image test. UCC, formation, battle of the forms provision, which could lead to potentially the knockout rule if there's conflicting terms, which could lead to potentially UCC gap fillers. Now, when it comes to contract execution, under the UCC, we have perfect tender, which means I need 500 red widgets. That's what I ordered. Under the common law, we have substantial performance. Hey, I was a few minutes late today. It was my dad's birthday, right? No, trust me, I always go over time. Trust me, you're going to get more than substantial performance. But even if I only gave you 98% of your time, that would not be rise to a material breach under the common law. So do you see how I did that? I played this game with myself. I have two older brothers. They were super close. They used to play games together. And then I was always the one playing with the dog or playing by myself. Maybe that's something that I'm good at. But you all have accountability partners. And if you don't have an accountability partner, reach out to your customer service representative and they'll put you back in touch. Play it with yourself or, sign up for a tutor and we can play this game together. But I really do think that the pinwheel of life concept or just quizzing yourself, ask your husband or your wife or your daughter, your mother or whoever to just quiz you about this material. I think that goes a really long way. So, we have the MBE February 2024 complete calendar. We can see we've crushed it. I mean, I'm really proud of where we started, where we've come. We did contracts, torts, con law, real property, civ pro, evidence, crim law, crim pro, and now we have 2 weeks of review. We have the questions on Thinkific. If you complete every single one of those assignments, you are guaranteed free access to the course in the future, not that you'll need it. And we will go out of our way to go above and beyond and make sure you do pass this time the next time because we will take responsibility because we feel that our assignments in this class has been comprehensive. We have the boot camp coming up and we encourage you to be continuously doing 100 questions per day until the exam. So I like to work, well, there's actually a lot of things that I could go over. I think the most important thing is we all recognize Billie Eilish for her amazing song, What Was I Made For? From the motion picture Barbie. But we're not going to watch it today, but you guys can watch it on your own. But then the other things that I want to go over are our cram guides, not just from this year, but also from the last year. Things I'm going to focus on in these review sessions are quizzing students to make sure they're on top of their game. And then I practice what I preach, cram guides and questionnaires. Those are the things. And of course, live questions, cram guides, questionnaires, and doing live questions together. We have 10 days of review. We have so much time to master this material. So if I go into the complete course, you can just go to the classwork and see, boom, cram guides for all subjects, the February 2024 cram guide, and the July 2023 cram guide. These 3 things are your holy grails. You should be reading them over and over every single day. I'm going to start with the cram guide that we created. And I told you I'm going to stick our logo on it and make it a little bit nicer, but Lord knows I've been a little bit preoccupied with not just my business, but also my life. Okay. I want everyone to lock in and pay attention because we're going to go over in the next 20 minutes or so every single point that we learned during our workshops. I know you think that you hear something one time and you learn it. That is not true. That's never been true. It never will be true. Repetition is the father of learning. You need to hear things over and 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 over again for them to really be something that you know and you know well. Let us begin. There are some promises that lack consideration, such as gifts, but are still enforceable under a theory of reliance, such as promissory estoppel. See, that's a kind of weird thought, but again, we have the same clown, different wig example. A promise to make a gift in the future is not enforceable unless injustice can be avoided only by such enforcement. I remember this question clearly. A looked like a good answer. Oh, this is a gift. You don't need consideration. But D gave us the caveat that unless injustice can be avoided only by such enforcement. That question is a great example of why whenever you get a question on the MBE, you must read it and read A, B, C, and D before picking your answer. Do not just say, oh, B looks good, because B could look good. It's like when you go to the ice cream shop, you see chocolate, you see vanilla, you see Rocky Road, but man, look at all the options, because it could be the way last one. That's that cake batter, super split sundae, banana, fire, fantastic ice cream that you had to wait until the end. Taste every flavor before you pick an answer. All right. Under the UCC, goods are identified under the contract when the seller places a label on them. For example, when the seller places the label on the kayaks, the goods have been identified. Easy. When the seller places a label on the kayaks, the goods have been identified. That's when they're identified under the UCC, when they put a label and they make it identifiable. The enforcement of a debtor's promise is a long-established exception to the pre-existing duty rule. For example, if a debtor owes a lender and the payment is barred by the statute of frauds, but the lender agrees to pay a smaller amount, this agreement is enforceable and does not lack consideration. We know the pre-existing duty rule. You already had an obligation to do something, so now you promise to do something else based on your prior obligation. That does not constitute consideration. However, there is such a thing as the exception to the pre-existing duty rule, and a long-standing exception is the promise to pay an outstanding debt. So look for that. There's a debt, it's barred by the statute of frauds, whatever. I'll pay you half of it. That new promise is a new promise, and it's enforceable under that new promise. You know, it doesn't relieve them from owing the rest of it, but I'm just saying that new promise on its own is a valid and enforceable promise that doesn't need its own consideration under the long-standing exception to the pre-existing duty rule, which is payment of a prior existing debt. Under the UCC, a buyer's duty to pay is conditioned upon tender to the seller. It's a tough question. Everyone gets this question wrong. So too, there's a little Shakespeare for you. If a contract is silent as to place of delivery and time of payment, the seller has no duty to deliver the goods at his or her place of business unless the buyer makes payment. I teach people about like a Best Buy situation. Like I order a new microwave. I don't know if they sell that at Best Buy. IKEA. I order a new couch from IKEA, right? And I fill out the form and say, Andrew wants a new couch. And I want the little section couch with the little square and the, cup holders and the massage. I want the best couch from IKEA. I guess IKEA is not the place to go. But anywho, if I don't pay for it, they have no duty to deliver it to me, right? And if it's silent about where I'm going to get it, I got to go pick it up from IKEA. So the understanding that is until I pay the money and show my dusty ass up to IKEA and eat their little meatballs, they have no duty to deliver. An offeror is the master of the offer and can expressly create conditions that prevail over, for example, the mailbox rule. So again, in contract law, there's a hierarchy of in contract law, there's a hierarchy in priority of what will prevail. Express conditions of the contract are the top of the hierarchy. If me and Tommy make an agreement that says, fuck the mailbox rule, fuck the perfect tender rule, fuck Tommy, you know what I mean? Like whatever we agree to, it's our prerogative. We are contracting. That's kind of the main tenet of contracts is good faith and express conditions, the four corners of the document, that's what creates a contract. That's just a general tenet. Then it would be, course of dealings between the parties, and then it would be trade usage and custom. I would say that's a general hierarchy of how we will read a contract. Express terms, course of dealing between the parties, trade usage and custom. The assignee stands in the shoes of the assignor. Nice, right? That's a key piece. Assignee stands in the shoes of the assignor, right? We saw that in a question I asked, and now that I think about it, I'm not sure if it was a property question or a contracts question, but remember on the bar, they don't tell you what the subject is, so just answer the questions. But I asked a student that, what's the difference between a sublease and an assignment? They said, oh, an assignment, both parties are liable. It's kind of the same thing. Like assignment, assignor, they stand in the shoes. We should understand that. At common law, modifications are enforceable if both parties provide consideration. Remember, under the UCC, as long as there's good faith between merchants, no consideration is necessary for a modification. Goods over $500 must be in writing. Sure, statute of frauds. Partial performance is not satisfied if goods are delivered but not accepted. If accepted, performance would provide acceptance, statute of fraud. This one comes to the question that everyone gets wrong. Oh, Tommy, and I don't know why I'm always using Tommy. I just feel like it's like the most unoffensive name in cancel culture 2024, right? But Tommy is shipping jewelry to Johnny, right? And it's some gold bars. And I saw it at first and I was like, ooh, is this a specially manufactured good? But no, it's just gold bars. It's not, Tommy engraved gold bars. Now he ships it to Johnny, over $500, got to be in writing, and it's delivered. Oh, well, that's, partial performance. No, it's only if he accepts the delivery. Just because you deliver it, and I look at him like, oh, this is a nice gold. This is fool's gold, right? Like, he doesn't accept it. It's only gonna remove the contract from the statute of frauds if the delivery is accepted. Remember the mnemonic: statute of frauds, contracts in contemplation of marriage, contracts that cannot be completed within 1 year, contracts for land, executorships, goods over $500, and suretyships. And then we remember the mnemonic, which is an exception to the statute of frauds, which is swap, specially manufactured goods, written confirmatory memo, admission in court, promissory stop, and partial performance. Good mnemonics to know. Goods over, we did that. Courts will not enforce contracts of adhesion. Ooh, that's a good vocab word. And I think one of the dopest things that we did this year was the real property vocab list. And that'll be great for my future classes. And, next year I'll have them doing for Civ Pro and we'll just keep growing. But, if I did one for contracts, I would have put this: court contracts of adhesion. It's just a good vocab word to mean. What does it mean? Essentially, contracts created under duress or threat where there's no meaningful alternative or choice. Essentially procedural unconscionability. So they use that term contracts of adhesion. It's pretty much like, they put a gun to your head and made you sign the contract. Undue influence focuses on the relationship of the parties. They love to test the difference between undue influence and duress. Duress is a threat. Undue influence is a relationship between the parties. You think of like a guardian or a nurse who's looking after a really old person and gets them to sign their estate over. An assignee can validly seek recoupment against an obligor for claims arising from the same contract. Again, that kind of deals with the standing in the shoes. What is recoupment? Recoupment is like A owes B, B owes C. C can seek a claim of recoupment on the AB debt because B owes C, A owes B. Well, let's just cut out B and let me recoup my money, just so you know. A hospital patient who gets sick is likely an incidental beneficiary of a contract between a janitor and the hospital, right? We saw that incidental intended beneficiary. One thing I've noticed about intended beneficiaries is people get this question wrong. I agree to pay money to anyone who sells you a car in the next month. I say that to Tommy. Tommy's like, all right, cool. Tommy goes, boom, boom, boom. Find Sally. Sally sells him a car. And Sally's like, yo, you told Tommy that you would pay anyone who sells him a car. Oh, no, you're an incidental beneficiary. I'm not paying you. Wrong. You are an intended beneficiary. As long as they are reasonably ascertainable, anyone who sells them a car, well, that's an intended beneficiary. So Sally sold Tommy the car. Andrew, the dumbass, has to pay Sally in this situation because Sally was a reasonably ascertainable intended beneficiary. Under the firm offer rule, if there's an options contract and offer that remains open between merchants, there's no need for consideration. And if the time for which the offer is to remain open is not stated, it'll be 3 months, after which the offer becomes revocable. If the 3 months pass, but the offer is not revoked the offer, then the offeree may still accept the offer. So if that went over your head, don't have enough time right now. It's just not my thing to explain the firm offer orders, that could take me all day, but you should know the firm offer, right? It's an options contract between merchants, no consideration is necessary. It will stay open if not stated for up to 3 months, at which point it becomes revocable and needs to be actually revoked for it to be revoked. So that was solid. That's what we did. And we're going to go over a lot more. I'm not leaving contracts in the dust. I tend to find that people don't do as well on contracts as they should because we do it first. And then, as is natural, you kind of forget about it by the time you take the test. I'm not going to allow that this time. We're going to stay on top of every single subject. I'm not sure I'm going to get through every single subject today, but the wheels are turning, right? I hope people are taking notes, having fun, drinking cranberry juice. Let's see what we got going on with torts. Remember 12/17, this was before Christmas. You guys have been putting in a lot of hard work, and I'm proud of each and every one of you. Children doing adult-like activities will be held to the adult standard of care. No shit, right? Kids driving the motorcycle, adult standard of care. If a girl is sneaking into your garage, you cannot punch her in the face because that is excessive force. Please do not punch little girls in the face. We're anti that for out now and forevermore. If a retailer, manufacturer, supplier, etc., sells a product without a safety device and the evidence shows that foreseeable injury would occur, they can be held liable under strict liability theory. Yes, we should all know about product liability, strict liability. Product liability, strict liability means precisely that if a manufacturer, supplier, retailer, distributor, or producer places a defective item in the stream of commerce, they can be held strictly liable. The different types of strict liability, products liability theories are express warranty, either failure to warn or inadequate warning, design defect, which would consider the risk utility test. Was it more risky than the utility of providing it some way? It could be a manufacturing defect. It was designed properly, but we made one differently than designed. Or it could be the implied warranties of merchantability, whether it works or not, it turns on. Or the implied warranty of fitness for a particular purpose, meaning it works for the reason it was represented to work. And then remember, there's always a contemporaneous argument for negligence. It was negligent to design it. It was negligent to manufacture it that way. But the strict liability theories are those: express warranties, implied warranties, manufacturing defect, and design defect. If you suffer a heart attack and it's totally unexpected and unforeseeable, then you're not liable because you not breached any duty of care, right? Tommy's driving down the road, heart attack, swerves into Johnny. I'm sorry, Johnny, you got hit. Maybe the insurance company will help you out, but it's not Tommy's fault, right? He didn't breach any duty of care. You do not have a duty to walk around expecting to have a heart attack, right? I'm gonna continue talking. All right. You do not owe any significant duties to an unknown trespasser. So for example, if you're shooting on your property, yeah, that's what we do outside, just shoot, and your neighbor trespasses onto your land and gets accidentally shot, you're not liable, especially if the neighbor knew you shot guns on the property, right? I'm out here in Maine, there's a bunch of woods. Man, I chased Rosie through the woods one day and I was so scared because I saw these like, deer hunter. People in Maine like to just sit and obviously drink beer. And they either do it in a tree because they're hunting deer, or they do it on a lake because they're ice fishing, right? But they just love to sit. So I saw these, deer hunting stands, and I see Rosie flying through the woods, and she's kind of like hefty, So I'm like, yo, if they think she's a deer and they hit her, I'm gonna be so sad. But anywho, let's talk about this fact pattern here. I shoot guns on my property. My next door neighbor knows I shoot guns on my property. His dumbass walks on my property and takes a bullet to the head. I'm not responsible. You are the dumbass who walked onto my gun shooting property. All right, let's continue. I'm sorry to use that word dumbass so much. It's just like, I don't know. It's better than defaming the greatest quarterback of my generation. All right. If a pilot makes an emergency landing, he's privileged to land, and the homeowner cannot send the dogs to attack, the old Monty Burns, because that's battery. Defense of necessity defeats defense of property in this situation. I know we fleshed that one out, but right. I'm a pilot making emergency landing. You can't send the dogs to attack me. That's the Monty Burns viciousness. He's from The Simpsons, if you guys don't know. The danger of falling off of a ladder is obvious and there's no duty to warn. Abnormally dangerous activities are non-delegable. The general contractor will be liable for the subcontractor. One such abnormally dangerous activity is blasting. That was our favorite word of the day. I think I remember recent class, it was fondling, right? This has been a weird class. We started off blasting and we ended up fondling, but that's what happens in this fucking bar world. Don't put that on me. So abnormally dangerous activities are non-delegable, right? The general contractor tells the subcontractor to blast. He blasts someone's head off. The general contractor can be liable, right? Abnormally dangerous activity, vicarious liability. Mishandling of a corpse leads to an actual claim by a relative for NIED, but it's not a strict liability tort. It's just that the mishandling of a corpse is especially likely to lead to distress. For example, mislabeling a corpse or failing to seal a body at a mausoleum. So they try to trick you with that. Like, it's kind of like slander per se, where damages are assumed. Like, we're going to assume if you mess up the body that it's negligent and there's damages, but it's not strict liability. The proper remedy for conversion is the complete price of the chattel before the damage, not the actual damage to the saw. So I go over to Tommy's house, I say, oh, that's a nice saw. I grab the saw, start sawing some stuff, and then I break the saw. Well, now I could get it fixed for $300, but it's $500 for a new saw. The damages are $500 because the damage is so substantial that I've converted it. I need to get him a new saw because if I put it back together, I duct tape it, it might not work out. All right. Common carriers such as airlines have an affirmative duty to protect passengers from other passengers, although it does not arise to strict liability. So common carriers such as airlines have an affirmative duty to protect passengers from other passengers, that does not allow to strict liability, right? Like, yeah, if the airline sees Tommy next to Johnny, Tommy's getting hammered and he's like, showing him his newest boxing technique and he chins him, like maybe the airline had a responsibility, especially if the facts say like they observed it and they did nothing and then they kept feeding Tommy drinks. If a dealership hires a reputable EMS firm that has EMTs and one of the EMTs causes injury, the dealership is neither directly or vicariously liable, right? Because they hired a reputable firm and the dealership hired a reputable firm, the firm hired the EMTs, so the dealership is absolved of liability. They didn't do anything wrong. You got to look for, did they breach a duty of care? A great defense to battery is that the defendant did not know he or she was striking a person, because then they would not have the requisite intent, right? If you didn't know you were striking a person, you couldn't have had the intent to do such a thing. To claim self-defense for battery, the defense must have been reasonable under the circumstances, objectively, not subjectively, right? So someone's running at me and I'm an idiot. They're not running at me. They're running that way. But I'm like, I haven't slept in days. I think they're running at me. So I like pull out my nunchucks and I slap them over the head. That's not okay, right? Because I was delusional. Just because I actually thought they were coming at me is not okay. It has to be reasonable for me to think they're coming at me. If anyone in my shoes would be like, yo, that dude's coming right at me, you shouldn't hit him with the nunchucks, then that would be okay. But it has to be objectively reasonable. If a drunk man punches someone on the plane, the airline cannot be held vicariously liable for battery because there's no special relationship, right? You're not going to be held vicariously liable for battery. You could be held liable for negligence, right? That you failed to separate them or something of that nature. All right, I feel like we should do con law and call tonight. So con law, to have standing, the case must be ripe. You cannot be considering to run for office and sue under a candidacy requirement statute, right? You can't be considering it. Ripe is too early, mootness is too late. Furthermore, if you're suing for a candidacy requirement, you must sue the election official, not your party's chairman, right? That's, you have standing. It's about who are you properly suing. The right to be a candidate is a fundamental right, but they would apply rational basis to alienage requirements because it's part of the governmental process, right? So right to be a candidate is strict scrutiny, but not if it's about alienage requirements. Like there's certain times when they can um lower the level of scrutiny if it's related to the governmental process. Like, here's one. Man, I am not political, but I'm gonna tell you all something, and I'm gonna admit my political beliefs right now. I am not enthused about Donald Trump versus Joe Biden. Neither one of those candidates speaks to me, Neither one of them gets me up in the morning like, that's my guy, that's my girl. It's just like, bro, we're doing these two dudes again. So I've kind of had the crazy idea, maybe I should be president. Shucks, I am only 34 years old. I could not run. Well, what strict scrutiny? Well, again, right to be a candidate, but it is the governmental process. They are allowed to have these restrictions. And again, that's age, so it's not, about my race, alienage, national origin, but it's just kind of an idea that, like, when it's about the governmental process, being a juror or being a candidate, you have to be born in America to be, everyone's like, Elon Musk should be president. I think he was born in South Africa or something. Maybe there's a way you can get around that, but I'm just saying, and I'm not saying everyone's saying he should be president. I don't know what people are saying. I don't listen to people, but like, there are certain restrictions we can have on the governmental process. So marriage is a fundamental right that triggers strict scrutiny. Camper, contraceptions, abortion, marriage, procreation, education, and right to raise your children. Privileges and Immunities Clause of Article 4 requires that states cannot impose residency requirements on non-residents without establishing a substantial interest justifying the classification. I promise you the answer to the question will not be privileges and immunities from the 14th Amendment. If it is, it would be about specifically the right to travel interstate. Otherwise, it will never be privileges and immunities from the 14th Amendment. It will be privileges and immunities from Article 4, which is about discriminating against out-of-staters. Only federal courts can issue habeas corpuses for individuals in federal custody. They love to trick you on that. I've heard tutors say there's no trick questions on the test. Yeah, right. Almost every question is potentially a trick question, right? Like, don't ever believe that. This is a very tricky test. It is true that there is a correct answer, and not to all questions. I've seen literally questions that'll be like, oh, there's two answers to this one. So like, no, there are trick questions, and there are questions that have potentially could have two answers. They should eliminate them, but like, don't believe that this test is minimum competency. You should shut up and pick it, and it's an easy test. This test is extremely hard. Every single question, you need to review every single answer and consider, are you picking the correct answer for the question being asked? And you need to read very carefully, because they can, and I'm going to use the word, trick you by saying, the governor of Florida issues a habeas corpus for the federal crime of whatever. You can't do that. You knew the law, but it was a governor, and only the federal courts can issue habeas corpuses, right? So just make sure that you read very carefully and don't get tricked. A ban on all forms of commercial speech, even if serving a compelling interest, likely is not narrowly tailored. For example, a statute banning all advertising of red meat in response to a proven link between red meat and cancer is overly extensive, right? Look for those really, all, every, only, must be, those words that are so absolute or so restrictive. I would look at them a little bit sideways. I'm not saying never pick them, because sometimes they're right. Sometimes it's like the right to extend the deadline for, motion for JMO cannot be extended. Like, that's, can't be changed. There's some things that are concrete, but be wary. If a government contractor has a bumper sticker that's political and the mayor discriminates against the company as a result, this is unconstitutional. It would only be constitutional if the speech of the government contractor speech negatively impacted his ability to perform his job, right? Like, I work for the mayor, I got a bumper sticker that says, like, keep on rocking in the free world. And he's like, oh man, like, I don't really believe with rock and roll or the free world. And I'm like, I don't care, bro. I'm just here to do my job. Like, you can't fire me for that. But if I had a bumper sticker that says, like, Mayor Tommy is a snake in the grass and, he can't do his job, that could be a little bit impacting his ability to perform his job. Again, look at the fact pattern. They probably won't make it so gray. They'll make it clear that it's just free speech. Commercial speech is subject to intermediate scrutiny. A 30-day probationary period for mailing accident victims is usually upheld as substantially related to government interest. Florida has this exact thing, the ambulance chasers, you can't, hey, Tom, you got an accident, like, here's my card. No, you gotta wait 30 days. Fraudulent or misleading commercial speech is not protected, right? Also, intermediate scrutiny could be gender-based discrimination, discrimination based on illegitimacy, like you are not the father. Or we also apply a heightened level of intermediate scrutiny for time, place, and manner restrictions when it comes to the First Amendment. A ban on movies showing sexual intercourse is a violation of First Amendment freedom of speech. Sex is art. If anyone remembers anything about the February 2024 administration, it was me telling everyone to go make art after this class, because that's what we need to understand, that it's only obscenity if it appeals to the prurient interest of humankind and has no artistic or literary value, but most things are artistic. Just a quick aside, I'll never forget this. I went to Tulane University as an undergrad, and my friend convinced me to take this glass blowing course. It was like, he was really artistic, and I was like, all right, sounds cool. So we're in there with the super hot glass, and we're making these things, and I had this great idea. I was gonna make a banana, right? I was so excited because I was like, it's a banana with the peels, and I presented on. I'm not good at art. Like, I'm good at teaching the law and finance. I'm not good at art. So I make this banana, and this teacher in front of everyone, I'm showing him, and the banana was just like one of my pieces. I made like cups. I made all these cool pieces, but the banana was like, my piece de resistance. And I show him all the pieces. He's like, all right, fuck all these pieces. This one. And he grabs the banana. He's like, this man has put a penis on a pedestal, and I absolutely love this. And I'm like, no, bro, that's a banana. Like, there's not a penis on a. I didn't say that. I was just like, just please give me an A. Like, I just put an A. Like, I don't care. But hope I made people laugh with that story. That was art, right? My banana was art. All right, anywho. Lost profits do not constitute a taking, and you cannot recover for the price of equipment that you plan to use because it can be resold. This assumes there's still economic viability to the land. For example, mining land is sold to a farmer, and the farmer can still farm. Okay, so this was a tough question. This was a takings question, where it's like they took the land and now they want to get money for the tractor that they bought. You're not going to be able to get that. Why? Because you can resell the tractor. It's the takings is like taking your either physical takings, right, eminent domain, or a regulatory taking, which under the Penn Central multi-factor balancing test means that they have deprived the owner of their investment-backed expectations, and they have left the land mostly entirely economically unviable. A taxi cab driver does not have due process right to be free from competition. That was a pretty easy question we did. Like, Tommy, the taxi cab driver, was mad because Sally was like taking business from her. Like, chill, buddy. Sally's more efficient at getting you to your location. All right. Organizations and groups may deny membership rights to people if allowing that person membership would significantly impair the stated purpose of the group. Refer to the Boy Scout v. Dale case. So again, a lot of these questions on the MBE for con law are actually going to refer to specific Supreme Court rulings. This is one of them. It's about the Boy Scout case. Like, the Boy Scouts are all about, I don't know, I was never a Boy Scout, but I guess they're about like being one with nature. Let's just say that. Now, let's say I want to join the Boy Scouts and I'm like the king of littering. Like, I just came out with my newest CD called Littering is Fun, Let's Trash the Environment. And now I go to apply to the Boy Scouts and they're like, well, we don't want you, you can't be a member. I'm like, what do you mean? It's my right to be a member. And they're like, dude, you're the king of littering and we're the Boy Scouts. We're here to support nature. That's what that's talking about. That specific Supreme Court case held, I don't even know the details of it, but that someone wasn't allowed to join the Boy Scouts and they were allowed to refuse that person membership because their membership would significantly impair the stated purpose of the group. Targeted discrimination against men, such as fathers, is subject to intermediate scrutiny. Same with women. Remember, gender-based discrimination is subject to intermediate scrutiny. But the key tenet here is that it's discriminating against the gender, and it's not just that the gender suffers as a result of the ordinance. Here's an example. So we have a law at a school that says that everyone must wear shorts that go below their knees. Well, all the boys, basketball players from the, and 2000s era, shorts go below the knees. It doesn't affect them. All the women are like wearing skirts, and they're the ones affected. The statistics show that 90% impact of this ordinance or law or whatever is on women. However, the ordinance was not targeting women, so therefore it is not subject to intermediate scrutiny. It has to be targeting them. A lot of this comes down to targeting. Two examples I can paint that are good and, finishing class, but I want people to hang on to some interesting examples, are when they ruled that you cannot use peyote. I was going to say smoke peyote. I don't even know how peyote is used. If anyone knows, don't tell the class. You'd be kind of incriminating yourself. But anywho, they said they're not allowed to use peyote in Arizona. And there was one Native American group that was like, what do you mean? Peyote, that's what we do every night. We woo peyote to the gods. Look, we're not targeting your religion by saying you can't use peyote. We're just saying it's not good for the health of the people, and therefore they're not going to be able to prevail. Now, here's another example. In Miami, they tried to pass a law saying you can't, sacrifice a goat. You're not allowed to sacrifice goats because it's not cool. Well, the what are they called?
Santeria.
Yeah, but what are the people called who practice it?
Santeros.
Santeros, exactamente. The Santeros were sacrificing goats, and they were able to prove that the law was specifically targeting them. It wasn't just like hey, we're trying to save the goats. It was like, we enacted this law specifically targeting them. They actually invalidated that law. That's a good example. Remember, con law is tough, Yeah, my man Matt Beckerman here explains some of these things that I can't, but a lot of it comes down to Supreme Court rulings, and that's a line that's been drawn where the peyote can't do it. We're not targeting. The Santeros were being targeted. That law is invalid. Be very hesitant to rule against a tax measure, even if the effect of a tax only applies to one state, but the purpose is rational, then the measure is valid under Congress's plenary taxing power. Again, broad plenary taxing powers. They enact a tax for the purpose of giving money to, play more football in rural areas because rah football, Taylor Swift, Usher, football, whatever. They could probably do it, right? The taxing power is plenary. Be very hesitant to rule against a tax measure for the purpose that this isn't related to anything. They have broad taxing powers. The state cannot put a bridge over your farm without just compensation, and allowing you to charge a fee is not equivalent, and therefore a taking has occurred, right? If I have a piece of property, they put a bridge over it, and they're like, oh, but you could charge people $20 to go over your bridge. It's like, bro, I don't want random people going over a bridge in my backyard. You guys have impaired the value of my land. It is a per se taking, sticking a stop sign on my land is a per se taking. That's my land. Now I have this ugly red sign on it. Not okay. I need just compensation. And then finally, superior officers are appointed by the president with the advice and consent of the Senate. That's just a nice, neat fact that we can end class with today. You see, just going over 3 of the cram guide details that we made in class, I think is super valuable. We're gonna, pick up next class, going over the rest of this cram guide. Other things I'm going to do is go over the July cram guide again. I'm going to go over the cram guides that I've made for every subject. I'm going to go over the questionnaires for every subject, and I'm going to continue playing that, spin wheel of life game where I'm asking students questions. And of course, we're going to jump into live practice questions, and just know we have 9 more days of general review. leave no stone unturned, and please come to every class with questions for me. I'm an open book. I'm here to answer every single question. I'll try to bring in some of my star tutors to help me and help support me, but I'm excited. I'm excited for the next 2 weeks with this class to really dominate this test. So I'm gonna go ahead and start this recording.